Hello and welcome to the Law Lab YouTube channel. Here we unpack and dissect everything legal. As usual, my name is Aaron Asido Entry. Once again, we are projecting or presenting live from the Jataba Media Network studios. And clearly you could see the difference in it. Levels don't change. We told you 2025, it is back to back to back. Today we are on our law student. One thing that is very important in the life of every law student and a lawyer is where he or she can find his laws, the sources of law. So today we are looking at sources of law in Ghana. No matter the course you are reading, no matter what you are speaking about, the first thing you'll be asked as a student of law or a lawyer is your authority. That is where you move in to find your laws to actually back whatever thing you are saying. So today we are projecting on sources or presenting on sources of law. In Ghana, when we mention sources of law, if you are having your constitution, I mean the big one, not the Makola type. When you move straight to page 10 of the said constitution, specifically Article 11 or Chapter 4, you get to know that we have the sources of law in Ghana clearly provided in Article 11 of our Constitution 1992. When you carefully read through Article 11 of our Constitution 1992, you get to know that there are basically 5 sources of law. And it's clearly projected over here. One, we have the Constitution, we have the Act of Parliament, we have subsidiary legislation, we have existing law, and the common law of Ghana. I'm sure you are surprised with the common law of Ghana because when you pick Article 11.1 of the Constitution 1992, you get to see that paragraph E would only write common law. But I say it is the common law of Ghana, and I'll prove to you why. So you have on the screen Article 11 of the Constitution 1992. I'll take my time to read through with you and explain why these are the sources of law in Ghana. So Article 11, Clause 1. Remember, the Constitution is read in articles, clauses, and paragraph. So with this, we have Article 11, Clause 1, Paragraph A. And it reads, the laws of Ghana shall comprise A, this Constitution. Now, our Constitution 1992 came or was promulgated on the 7th of January 1993. Remember, in the celebrated case of Tufor and Attorney General, Sowa JSC told us something. He mentioned that the Constitution has its letter and same has its, or it equally has its spirit, and that the Constitution should be construed as a living organism capable of growth. Because our framers of the Constitution thought, which was promulgated in 1993, knew that the Constitution should be capable of growth. Since we are moving and we don't know when we'll be having the next Constitution of the Republic, they actually, or the framers of the Constitution, took their time to make it quite flexible for it to grow with us. In 1993, there was no oil. Ghana found its first oil somewhere 2007 under President Kufuor. In 1993, there was no TikTok. In 1993, there was no WhatsApp. There was no social media. And so, the framers of the Constitution now thought it wise to create the second source of law. It goes ahead to say that B, enactment made by or under the authority of the Parliament established by this Constitution. When you read Article 93 of our Constitution 1992, you get to know that the Parliament of Ghana is established by this Constitution and shouldn't have less than 140 members. And if we know this, the framers of the Constitution, knowing that after 1993, which the Constitution was promulgated, there can be no addition to the Constitution, they created the Parliament of Ghana to be making laws. In fact, the Constitution goes ahead at under Article 299 of the Constitution 1992 to leave residual powers in Parliament to be making laws in order to augment this Constitution. The only condition under this is that per Article 1, Clause 2 of the Constitution 1992, the Constitution shall be the supreme law of Ghana, and any other law found to be inconsistent with any of the provisions in the Constitution to the extent of inconsistency shall be void. Meaning, even though Parliament is having the residual powers to be making laws, Parliament cannot make laws which are inconsistent with the provisions of the Constitution. So in 93, Constitution came into force. Now we have Parliament who has to be making residual laws or be making laws to augment the gaps that was left by this Constitution. Remember, it is Parliament that needs to be making laws to actually regulate the oil Ghana found in on the land of Ghana. Now the third one is any orders, rules and regulations made by any person or authority under a power conferred by this Constitution. Now let's get this clear. This Constitution can create a body here and give it power. Say the Electoral Commission, say Ghana Police Service, say Ghana National Fire Service, Ghana Armed Forces, amongst others. These are constitutional bodies who can make laws on their own, and they are here. Parliament, as an example, let's even pick the current parliament we are having. You pick let's say the member of parliament for Okankwe Central, the Honorable Patrick Yalboama, is what do we call it? A lawyer. He's a lawyer. You pick the member of parliament for Lejekuku, Bernard Ayiku or Ayiku, the Honorable Ayiku, who is into the oil sector, because I know he has some filling stations amongst others. Pick the member of parliament for my own constituency, the Abrim constituency, the Honorable Charles Esuaku Oridu. He is a diplomat into the foreign affairs matters. And pick my own very good senior brother, the Honorable Asafueji, Nana Kwame Asafueji, who is into governance and also foreign affairs. Putting these people in the chamber to be passing laws about oil will be problematic, because all these people have mentioned, it is only the Honorable Ayiku who has some level of experience and knowledge in the oil sector. So Honorable Nana Kwame Asafueji, Honorable Patrick Yalboama, and the Honorable Charles Esuaku Oridu may be found lagging or lacking at this area. So in the best interest of Parliament, Parliament can also create bodies like the National Petroleum Authority, like Ghana National Petroleum Corporation, like Petroleum Commission and others, to be also making laws or regulating our oil sector. So when you pick these bodies created by the Constitution, like the Electoral Commission, like the Ghana Police Service, like the Ghana Armed Forces, like the Ghana National Fire Service, amongst others, and you pick these parliamentary bodies, like the National Petroleum, or these bodies created by Parliament, like the National Petroleum Authority, like the GMPC, Ghana Gas, amongst others, they fall here. They fall under any orders, rules and regulations made by any person or authority under a power conferred by this Constitution. So the constitutional bodies, when they make laws under this authority or under this provision, we call those laws CIs, constitutional instruments. It is why anytime we are going to have an election, you'll be hearing the EC has submitted CI 127, CI so and so to Parliament, amongst others. With the parliamentary bodies like MP and Ghana Gas, GMPC and others, when they make laws, because they are parliamentary, they are legislative bodies, we call those laws allies. We call those laws allies. The next one we'll be looking at is existing law, and the last one will be the common law of Ghana. I'll pick the common law of Ghana first, because when you read Article 11.2, it says, the common law of Ghana shall comprise the rules of law generally known as the common law, the rules generally known as the doctrines of equity, and the rules of customary law, including those determined by the superior courts or of judicature. Sorry, it's of judicature. Meaning, when we talk of common law, the common law of Ghana, we are looking at three things. The normal common law, if you've watched my video on how to become a lawyer, I briefly explained what the common law comprised of. And there were deficits in the common law because the common law was only in a writ system, meaning if you don't find your offense in the writ book, you get to lose out. And so the rules of equity, or the doctrine of equity, for the sake of fairness, came into being, meaning equity came to augment or follow the common law. It is a maxim in equity. We say equity follows the law, however, not slavishly not slavishly. I think we will have time to explain equity very well. The rules of customary law, meaning our customary law, which the Superior Court is saying that it's now a question of law and not a question of fact, meaning all customs now must pass the test of reasonability for it to be admitted. It goes ahead to talk about for the purposes of this article, customary law means the rules of law which by custom are applicable to a particular communities in Ghana. Now the fourth, Article 11, Clause 4, Clause 5, and Clause 6 talks about existing law, and I'm taking them seriatim. Article 11.4 says that the existing law shall, except as otherwise provided in Clause 1 of this article, comprise the written and unwritten laws of Ghana as they existed immediately before the coming into force of this constitution, and any act, decree, law, or statutory instrument issued or made before that date, which is to come into force on or after that date, meaning all laws that existed before the coming into force of the Constitution 1992. So when you pick our Contract Act 1960 at 25, this Contract Act came into force somewhere 1960, but it is deemed as an existing law because we keep on using it. The next one is subject to the provisions of this constitution. The existing law shall not be affected by the coming into force of this constitution. Yes, if you're having an existing law, I think we will have time to be learning about coup d'etat, to be looking at the legal effect of existing laws and others. But Article 11.5 says something very instructive, that subject to the provision of this constitution, subject to the provisions of this constitution. This is instructive. The existing law shall not be affected by the coming into force of this constitution. Remember, we are saying that generally existing laws shall not be affected by the coming into force of this constitution. However, there is a caveat over here, subject to the provisions of this constitution. Let us look at some of the provisions of this constitution that will affect our existing laws. So let's look at 6. It says, the existing laws shall be construed with any modifications, adaptations, qualifications, and exceptions necessary to bring into conformity with the provisions of this constitution, or otherwise to give effect to or enable effect to be given any changes effected by this constitution. The simple understanding you need to get is that, remember I mentioned early on that Article 1.2 clearly states how the Constitution is supreme. So if any existing law is being inconsistent with the Constitution, we will now construe it with any necessary modifications, adaptations, qualifications, and exceptions necessary to bring that existing law into conformity with the Constitution 1992. So let me give you an example, a practical one. In the case of Ahuma Okansi versus the Attorney General and the Electoral Commission, and also Churchill, it was an association, a human rights association, versus the Electoral Commission. It's a joint case. In that case, Churchill actually was seeking in the 2008 election that prisoners should be allowed to vote. Prisoners should be allowed to vote. However, Ahuma Okansi, on the other hand, was saying that for him, whether prisoners or those even in detention should be allowed to vote, because pursuant to Article 42 of our Constitution 1992, it gives only a 3 test. You must be a Ghanaian, you should be 18 and above, and of sound mind. So if the person is in detention or the person is in prison, provided the person is 18 years and above, a Ghanaian and of sound mind, that person should be permitted to vote. The EC came out quoting a certain PNDC law, we put it on the screen, stating clearly that PNDC law is saying that the prison cannot be described as a home. The prison cannot be termed as a home or place of abode, so they cannot actually register those in prison or detention. The Supreme Court made a determination on that matter, that existing law should actually, that portion of the existing law should be expunged or should be quashed, and as such, Article 42 should be held in its high esteem. That for you to qualify to vote, you need to pass a 3 test. You should be 18 years and above, you should be a Ghanaian, and should be of sound mind. Basically, that is it. Now, the point here I want to raise is that, remember I mentioned that we have constitutional bodies and legislative bodies. I use the Electoral Commission as an example under Article 11 Clause 1C, and also I use the National Petroleum Authority as also an example that I mentioned that the EC makes CIs, constitutional instruments, and the MPA will be making LIs. But the point is, does the MPA and the Electoral Commission have legislative powers? Now let's prove it in the next slide. The next slide, that is, any order, rule, or regulation made by a person or authority under a power conferred by this constitution or any other law shall A. be laid before Parliament, B. be published in the Gazette on the day it is laid before Parliament, and C. come into force after the expiration of 21 sitting days after being so laid, unless Parliament, before the expiration of the 21 days, annuls the order, rule, or regulation by the vote of not less than 2/3 of all members of Parliament. So basically what we mean is that those constitutional bodies and the legislative bodies, they do not have legislative authority to be making laws. So even when they draft their laws, they have to lay it before Parliament. And when they lay it before Parliament, Article 11 Clause 7 is saying that they must publish on that same day they laid in Parliament in the Gazette, so that people will now be writing to Parliament that, Charlie, this rule the Electoral Commission is bringing for this election is problematic, amongst others. I think running up to the 2024 election, we saw the minority leader then, now majority leader and Minister of Finance designate, making a whole lot of complaints about the EC, raising that we are going to use Ghana card to vote, amongst others. And so when you lay it before Parliament, publish it in the Gazette, the condition here is that you lay it before Parliament, it will come into force after the expiration of 21 sitting days. You need not to do anything. You, the constitutional body or the legislative body, you need not to do anything. Wait for Parliament to sit 21 times. After that, it becomes a law. If Parliament does not want it to become a law, all that they need is that they need vote of not less than 2/3 of all members of Parliament. So now Parliament is about 276. You can do the calculation, and I believe the NDC or the people on the majority caucus have the numbers to annul any legislative instrument or constitutional instrument. This basically, we've actually looked at the sources of law, running through the 5 sources of law, i.e. the Constitution, Act of Parliament, subsidiary legislation, the existing law, and the common law of Ghana. Thank you very much for keeping up with us. This has been the Law Lab. Just as I've always been saying, do not leave all your matters to God. Take some to your lawyer. Kindly subscribe, like, comment, and share to your friends. My name remains Aaron Asiedu Entry. Thank you very much.